Yes.
Chukwudi. Respectfully, my lord, Chukwudi Adiuku for the defendant, my lord.
In reading the judgment, I shall simply read the introductory portion and the claims, and then I shall proceed straight to the decision section.
As God pleases.
As God pleases.
Judgment. The claimants filed this complaint against the defendants on March 12, 2015, together with the accompanying processes, seeking the following reliefs. 1, an order directing the defendants to pay the claimant the sum of 14,400,000 naira only, consisting as follows: net monthly emoluments due and unpaid amounting to 12 million, covering the period October 2011, January 2014 to October 2014. B, annual leave allowance amounting to 2 million, covering a period of 2 years, specifically 2013 and 2014. 2, interest sum of 14,400,000 naira only at the rate of 12.21% per annum from the day judgment is. 3, a declaration that by virtue of Section 2B and Section 91C1 of the Pension Reform Act 2004, the defendant, as a private organization employing more than 5 persons, is bound to remit 15% of the claimant's monthly emolument to the claimant's nominated retirement savings account, made up of a contribution of 7.5% each by the claimant and the defendant of the claimant's monthly emolument. 4, an order directing the defendant to remit to the claimant's retirement savings account the sum of 3,213,000 only, being the claimant's due and unremitted pension contributions as at 31st October 2014, and 2% penalty fee for late remittance of pension contributions, consisting the sums of A, 3,150,000 naira for the period covering September 2011 to October 2014, excluding August 2012, September 2012, and November 2012. 5 months at 90,000 naira per month. B, 63,000 naira being 2% penalty fee for late remittance of the pension contributions. 5, cost of this action, 500,000 naira. The defendant entered a conditional appearance on 4th March 2016 and filed the statement of defense together with the accompanying processes. The defendant claimed against the claimant as follows. 1, the sum of 10 million naira only, being money paid to the claimant as salaries for the period between February to November 2011, as the claimant was still gainfully employed at Aero Contractors and did not resign the said appointment until November 2011. Or in the alternative, 1, an order of this honorable court setting up the above stated counterclaim as against any amount owed the claimant. 2, cost of this counterclaim. 3, such further orders as the honorable court may deem fit to make in the circumstances. I will go straight to the decision portion. Just a minute. Um, So, Registrar, are you still on? Are you on? All right.
Yes, my lord, we are hearing
All right.
you.
Okay, all right. I go to the decision portion now. I have carefully considered the originating processes, the evidence, the submissions of counsel and authorities relied on in the findings. The claimant's complaint in this suit is that the defendant has failed to pay him his salaries, leave allowances, and has failed to remit pension contributions to his pension account as agreed in the employment contract. It is the law that whoever desires the court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove those facts exist. 1311 and 2 of the Evidence Act, 2011, also see Calabar Cooperative Limited versus ECHO. In the determination of employment rights, it is the employee who complains that his employment contract has been breached that has the burden to place before the court the terms and conditions of his employment that provides for his rights and obligations. Siokoibo versus Police Council, Okomopo Company versus Iserienria. The claimant has placed before the court his letter of employment, Exhibit C1, Diamond Bank Statement Account, Exhibit C2, Trust Fund Pensions Retirement Savings Account Statement, Exhibit C3, Demand Letter, Exhibit C4, Confirmation of Employment, Exhibit C5, Resignation Letter of Aero Contractors, Exhibit C6. The defendants who have counterclaim have placed before the court emails dated 5 May 2014, Exhibit 1.
Registrar, please, we can't hear the court anymore.
Yes, you have muted the court.
This. Can you hear me now?
Yes, my lord.
Can hear me now? Yes, okay. I will begin again. The claimant has placed before the court his letter of employment, Exhibit C1, Diamond Bank Statement of Account, C2, Trust Fund Pensions Retirement Savings Account, C3, Demand Letter, C4, Confirmation of Employment, C5, Resignation Letter from Aero Contractors, C6. The defendants who have filed have placed before the court emails dated 5th May 2014, Exhibit D1, and 23rd June 2014, D2. Notice of arbitration, D3, letters to Pension Commission, D4 and D6. Letter from Pension Commission, D5, letter dated 20th November 2014, D5. Letter dated 10th December 2014, D6. Claimant's letter of resignation from Aero Contractors, D7. arise for determination as follows. 1, whether on the pleadings and evidence the claimant ought to be entitled to his claims. 2, whether the defendant is entitled to its counterclaim. The defendant employed the claimant with effect from February 1, 2011. His net annual pay, inclusive of pension deductions, is Naira. Net monthly pay, 1 million Naira, and annual leave allowance is 10% of net annual emolument, as seen in the employment contract exhibit C1. The law is settled that parties are bound by the terms of the employment contract. See Sharu versus Federal Poly Kara Namoda. See Gateway Bank Nigeria versus Abosede, and CDA Alep versus Uluwadari. I hope Council can still hear me because we're having problems. Can you hear me, Council?
Yes, my lord.
Please?
Yes, my lord, we can hear you. Yes,
We are hearing
Yes,
you.
because we're having a little bit of disruptions. That's why. The claimant has made a claim for salary for the months of October 2011, January 2012, January 2014 to October 2014, and leave allowance for the years 2013 and 2014, and pension. Of this, he has put in evidence Exhibit C2 and C3, which are his bank statements from Diamond Bank PLC and Trust Fund Pensions Retirement Savings Account. Exhibit C2 does not show that the defendant paid the claimant's salaries for the months being claimed. I note that Defense Counsel has once again in final address objected to these documents. At the trial, he objected to the admissibility of these documents at the proceedings of May 2019. The objection was overruled in a ruling and the documents were admitted. It is surprising that Defense Counsel has raised the same objection at final address when he had adequate and ample time to file an appeal. He chose not to do so. It appears he did not read the entire ruling or grasp the reasoning. If he had, he would not be raising the same objection once again. It is the law that civil suits are decided on of probabilities on the preponderance of evidence. The burden of proof is not static, but shifts from side to side. The onus of adducing further evidence is on the person who will fail if such evidence is not adduced. See Danjuma versus SCC Nigeria, Osuji versus Ikiocha, Fadala versus Arewa Texas. The defendant has not adduced any evidence in rebuttal that the outstanding salaries and leave allowances claimed by the claimant. Instead, the defendant has relied on Exhibit D1, dated Monday, 5 May 2014, and Exhibit D2, dated Monday, 23 June 2014, which are general memos addressed to, and I put in quotes, everyone, and in which it has admitted that it owes all its employees salaries, and this includes the claimant. It is the law that facts admitted need no further proof. See Adusi versus Adebayo, Unity Bank PLC versus Denclap Limited. I find that the defendant has not paid the claimant his outstanding salaries. The defendant's reason for not paying the claimant his salaries is that it is involved in a dispute and a pending arbitration with Chevron, its major clients. This has affected its business. The claimant has denied knowledge of this and has also denied receiving any email in his personal email address or the general email address from the defendant in April 2014, placing him on compulsory leave without pay or reducing his salary by 50%. I find that Exhibits D1 and D2 were not addressed to the claimant's email address. There is no evidence in rebuttal, and the defendant has failed to discharge the shifted burden. The defendant's dispute or arbitration with its clients does not suspend the fundamental terms of payment of salaries and allowances expressly mentioned and stipulated in the employment contract that is binding on the parties. Salary and allowances are a fundamental term of the employment contract. The defendant must obtain the claimant's express consent in writing, authorizing a salary deduction. There is no evidence that the claimant consented to a salary reduction. DW asserts that the claimant stopped work in April 2014 and is not entitled to salaries 2014. The claimant disputes this and asserts under cross-examination that he flew for the defendant in June or July 2014. In resolving this issue, I will reproduce the defendant's pleadings as follows. 4. Defendant avers that it had essentially lost its major contract with Chevron and was struggling to keep the business running, and as a result of which, defendant had to ask staff to go on a compulsory leave in April 2014. This decision was clearly communicated to the claimant and other members of the staff at a meeting held on 29 March 2014. Defendant shall at the trial of this suit rely on the email correspondence with members of staff. 5. The claimant avers that further to paragraph 4 above, it scales down the operations, cut staff salary by 50% for those working during the period, which included the claimant's hearing until the defendant could stabilize its business by resolving the impasse between the defendant and its principal client, Chevron Nigeria Limited. 6. The defendant avers that as of June 2014, there was still no headway with resolving the dispute with Chevron over unpaid invoices, and the bids to get NAPIMS to wade into the matter to get Chevron to reinstate the defendant on the contract. As a result of this, the defendant sent an email on 5th May 2014 and 23rd June 2014 through their HR manager, Ikeme Audu, to all staff, notifying them of this development and placed staff on compulsory leave indefinitely until such a time that it could resolve the dispute and bring everyone back on board. The defendant pleads and shall rely on a email dated 5th May 2014 and 23rd June 2014, respectively. It is the law that parties are bound by their pleadings. See Ayonfulu versus Mecca. The defendant has pleaded that the claimant was working during the period, and it sent emails to all staff on June 23, 2014. The claimant was therefore in the employment of the defendant in June 2014. I believe that he worked for the defendant in June 2014. There is no evidence, however, that the claimant continued to work for the defendant after June 2014. Consequently, the claimant is entitled to his salaries for the months October 2011, January 2012, January 2014 to June 2014. Of 8 months. The defendant is ordered to pay the claimant the sum of 8 million naira as outstanding salaries. Are we still on?
Yes, my lord. Yes, my lord. We're here. As God pleases.
Okay,
Yes,
I
my
can
lord.
see we're having some problems from the host. I can see it on my system. Okay, all right. The claimant has made a claim for annual leave allowance covering the 2013 and 2014. His letter of appointment provides, and I quote, that leave allowance is payable on individual accounting year end. It also states that annual leave period is 9 weeks, and I quote, your leave allowance is 10% of your net annual emolument. There is no leave allowance paid to the claimant in 2013 in Exhibit C2, and there is no evidence in rebuttal by the defendant. From the evidence adduced, the claimant is only entitled to leave allowance for 2013 and not for year 2014. The defendant is ordered to pay the claimant his leave allowance for year 2013 in the sum of 1,200,000 naira. The claimant is seeking a declaration that by virtue of the provisions of the Pension Reform Act 2004, the defendant as a private organization employed more than 5 statutorily bound to remit 15% of his monthly emoluments to his nominated retirement savings account, made up of a contribution of 7.5% each by him and the defendant monthly. It is mandatory by the provisions of Section 1(2)(b) of the Pension Reform Act 2004 that the contributory pension scheme shall apply to all employees in the private sector, employment in an organization in which there are 5 or more employees. The defendant has admitted in its pleadings that it is a private organization employing more than 5 persons. Section 91(c)(1) and 2 provides that the rate of contribution to the scheme shall be a minimum of 7.5% by the employer and a minimum of 7.5% by the employee. Section 11(5) provides that the employer shall deduct at source the monthly contribution of the employee in his employment and not later than 7 working days from the day the employee is paid his salary, remits an amount comprising the employee's contribution and the employer's contribution to the custodian specified by the pension fund administrator of the employee to the exclusive order of such administrator. Section 11(7) provides that any employer who fails to remit the contributions within the time prescribed shall, in addition to making the remittance already due, be liable to a penalty to be stipulated by the Commission, provided that the penalty shall not be less than 2% of the total contribution that remains unpaid for each month or part of each month continues, and the amount of the penalty shall be recoverable as a debt owing to the employee's retirement savings account, as the case may be. The evidence of the claimant's trust fund retirement savings bank accounts statement, Exhibit C3, shows pension remittance for the period February 2011 to November 2011 and remittance for August, November 2012. The period in which there was no remittance is January to July 2012 and December 2012 to June 2014. This is a period of 26 months. The defendant fails to lead any evidence in rebuttal to prove that it made the statutory remittance. The sum to be remitted, which is made up of the claimant's 7.5% monthly contribution, 40,000, and the defendant's 7.5% counterpart contribution, is a total of 2,340,000 naira. The defendant is ordered to remit this sum to the claimant's retirement savings account. The sum of 63,000 naira claimed as 2% penalty for late remittance is refused. The penalty is to be stipulated by the pension as provided by the law, and this entails a report being made to the Pension Commission by the claimant. On the whole, the case of the claimant succeeds. The defendant has counterclaimed for the sum of 10 million naira, being money paid to the claimant as salaries for the period between February to November 2011. The defendant asserts that the claimant worked with it and Aero contractors between February 2011 and November 2011. The claimant's evidence is that the defendant was well aware that he was still in the employment of Aero contractors, as the defendant was not yet in operation due to a delay in the delivery of its aircraft, and that he resigned his employment with Aero contractors in November 2011, when the defendant's aircraft arrived. The claimant was examined on this crucial evidence. It has not been controverted. The claimant asserts that the defendant did not take out any disciplinary measures against him all along because it was in the know all along, and his contract does not prevent him from holding another job. The claimant's employment contract, as stated in Exhibit C1, is also governed by the defendant's handbook. The handbook evidence to enable a determination on this issue. From the evidence adduced, I find that the defendant knew the claimant had not resigned his employment with Aero Contractors, and it condoned this for 10 months. No disciplinary sanction or measure was taken against the claimant on this issue throughout the entire employment relationship that spanned a period of about 6 months. The defendant is therefore stopped from raising this issue, having condoned it. I hold that the defendant condoned the claimant's continued employment relationship with Aero Contractors simultaneously. The defendant is therefore not entitled to the sum of 10 million naira. The counterclaim fails and it is hereby dismissed. For all given above, I hereby declare and make the following orders. 1, it is declared that by the provisions of Section 1, 2B, and Section 9, it is declared that by the provisions of Section 1, 2B, and Section 91C1 and 2 of the Pension Reform Act 2004, the defendant, as a private organization employing more than 5 persons, is statutorily bound to remit the claimant's 7.5% monthly pension contribution and its own 7.5% counterpart pension contribution, making a total of 15% of the claimant's monthly emoluments to his nominated retirement savings account. 2, the defendant is ordered to remit the sum of 340,000 naira to the claimant's retirement savings account. 3, the defendant is ordered to pay the claimant the sum of 8 million naira being outstanding salaries due to him. 4, the defendant is ordered to pay the claimant the sum of 1,200,000 naira being leave allowance for year 2013. 5, the defendant is to pay the claimant costs assessed in the sum of 150,000 naira on the main claim and 150,000 naira on the counterclaim, a total of 300,000 naira costs awarded the claimant. All sums are to be paid within 30 days. Thereafter, any sum outstanding will attract simple interest calculated at the rate of 10% per annum. Judgment entered accordingly.
As the power pleases. We are most grateful, my Lord, for the very well-reasoned judgment. And we thank my Lord for the indulgence in coming all the way from Abuja, the inconvenience we put you through. I'm most grateful.
Well, the soft copy,
thank you, my Lord.
The soft copies of the judgment will be cancelled by the registrar of the court pending when the hard copies, that is the certified true copy signed, gets to Lagos.
I'm grateful, my Lord.
So as soon as the hard copies get to Lagos,
thank you,
the registrar will contact you, or you can contact the registrar. But the registrar will send you the soft copies pending.
I'm very grateful, my Lord.
Thank you, my Lord. We're very grateful. Thank you, my Lord. And Happy New Year to my Lord.
Same to you.
Thank you, my Lord.
Adiku, you don't chop something there.